Hi, everyone, and thank you for joining us for today's webinar, 2024 Virginia Energy General Assembly Legislative Update. My name is Brad Nowak. I'm a partner and co-chair of the Renewable Energy Practice Group at Mullen. Our Renewable Energy Practice Group has a comprehensive team of over 30 attorneys and other advisors who help clients navigate all aspects of the development, permitting, financing, construction, operation, and sale of renewable energy projects. I'm very pleased to be joined this morning by my colleague, Chris McDonald. Chris is an attorney and lobbyist who serves as Director of Government Relations with the firm's Government Relations Group and is a member of our renewable energy team. Chris provides lobbying services to clients before Virginia's legislative and executive branches of government, including state agencies and boards. Chris has extensive experience in lobbying key renewable energy legislation in Virginia on behalf of renewable energy industry groups, associations, and developers. In addition to Chris, Mullen's government relations team has several other team members who represent clients in government-related actions at the state and local levels, with a special focus on Virginia and North Carolina. Before we kick off today's program, I have a few housekeeping items to go over. At any point during the presentation, you may submit questions by using the Q&A button at the bottom of your screen. We'll answer questions at the end of the presentation, time permitting. If you're having any audio or technical problems, please use the same Q&A button and someone will help get those resolved. And finally, you'll receive a copy of today's PowerPoint by email later today. We have a lot to get to this morning. During today's webinar, we'll start by providing a general overview of this year's General Assembly session. Then we'll provide an update on the State Corporation Commission's new commissioners, which is certainly welcome news. Then we'll walk through several key energy bills before this year's General Assembly, including shared solar expansion in Dominion's territory and a new program in Appalachian Power's territory, bills to establish a minimum period of validity for land use permits. Permitting reform was also a big topic this year, and we're going to cover bills commonly referred to as the Michigan model and the solar bans bills. There are also bills addressing where actions relating to the Virginia Department of Environmental Quality final decisions are to be held, changes to net metering and rooftop solar leasing, and mandatory solar disclosures and consumer protections. There are also several bills addressing Virginia's brownfield and coal mine renewable energy grant fund and program, and the regional greenhouse gas initiative. And then lastly, we'll cover some bills affecting offshore wind and small nuclear modular reactors. At the end of today's presentation, we'll hope to have time to cover a few questions. So with that overview, let me pass the program off to Chris.
Thanks, Brad, and thanks everyone for joining us. I look forward to this webinar really every year, so I'm excited to be back with everyone this morning. A few quick items before I begin. First, this webinar offers really but a glimpse of what went on in the General Assembly this session. We only have half an hour to cover a lot of material, so in the interest of time, we've really tried to highlight only about 20 or so of the most important bills or issues that we tracked or worked on this session. Even with these bills, these are in large part going to be summaries highlighting, the key issues, the key initiatives, and the legislative history. So we'll be largely addressing things at a high level, and we'll be moving at a pretty decent clip. So if you have questions about these bills or frankly any other bill or issue that we don't address today, please don't hesitate to reach out and ask. As Brad noted, we'll try to get to questions at the end, but if we run out of time, we'll be happy to follow up with you individually. And as always, I welcome you reaching out to me directly after the webinar as well. So let's get started. Before diving into this session's legislative work, we need to first set the table a bit and provide some context into the landscape of the General Assembly this year. This past November, every member of Virginia's House of Delegates and Senate were up for a re-election in brand new districts. Between a wave of retirements and both primary and general election challenges, we began this session with historic turnover. Specifically, we had 18 new senators out of 40 total and 31 new delegates out of 100 total, meaning that over 1/3 of the General Assembly was new. The institutional knowledge and subject matter expertise that we lost can't be understated, setting up a challenging landscape for us lobbyists in January that required not just meeting, but educating dozens of new legislators. These November elections also changed the political dynamics in Virginia. Democrats maintained a narrow majority in the Senate, 21-19, and they reclaimed a narrow majority in the House, 51-49. Governor Glenn Youngkin, a Republican, remains in office, as does Lieutenant Governor Winsome Sears and Attorney General Jason Miyares, both Republicans. We also saw lots of turnover in leadership. Delegate Don Scott ascended to Speaker of the House, while Senator Scott Surovell was elected Senate Majority Leader. And most relevant to our energy issues, Senator Creed Deeds was named Chair of the Senate Commerce and Labor Committee, while Delegate Juwan Ward reclaimed her position as Chair of House Labor and Commerce. Next slide, please. This year, we enjoyed the so-called long session in Virginia, which is quite the misnomer as it lasts just 60 days. This is in contrast, of course, to last year and every other odd-numbered year where we have short sessions that usually last 45 days. This year, the General Assembly convened on Wednesday, January 10th, and adjourned on time and with a budget on Saturday, March 9th. Between our returning veteran members and all of our new members, there were no shortage of bill ideas, and that translated to nearly 3,600 bills and resolutions being filed this session. This was even with the Senate imposing bill limits on their members. I looked it up this morning, and this is actually around 450 more bills than were filed during the last long session in 2022. Of these, just about 1,000 bills, and I mean bills, not resolutions, made it to the governor's desk. The Virginia Public Access Project reports that this is actually the highest percentage of bills passed since 2021, which is not surprising given that the Democrats control both the House and Senate this year, as they did in 2021. While this Democratic control may have resulted in a lot of bills being passed, as mentioned before, we still do have a Republican governor who still very much has his own legislative priorities and policy positions. Thus far, the governor has signed 264 bills, but he's vetoed another 91 bills. This actually brings his total veto tally to 132 over the last 3 years, which breaks the all-time gubernatorial record previously held by Governor McAuliffe. And we've still got hundreds of more bills to act on. For all of the bills that have not already been signed, amended, or vetoed, Governor Youngkin has until 11:59 on Monday, April 8th to act. The General Assembly will then return to Richmond on April 17th to address any amendments or vetoes that he sends down. I will note that for the vast majority of the bills that we discussed today, they still await action for the governor, so please stay tuned for updates. Next slide, please. All right, now that we've set the table, we can get into the good stuff, and we can start with some good news with the SEC. We have new commissioners. As I'm sure every single person on this webinar is keenly aware, for over a year now, the SEC has been down to just one commissioner, Judge Jamal Hudson. Judge Angela Navarro was not confirmed to a full appointment by Governor Youngkin at the outset of his term, leaving us with one vacancy, and then Judge Judy Yogman resigned from the SEC at the end of 2022, leaving us with a second vacancy. Following 2 years of stalled negotiations and legislative battles, finally, this session, the General Assembly elected 2 new commissioners, Sam Towle and Kelsey Baggett. Mr. Towle has served in a number of capacities here in Virginia, most recently as Associate General Counsel for Smithfield Foods, as well as Deputy Attorney General and Deputy Secretary of Agriculture and Forestry. Ms. Baggett previously served as a senior attorney with NextEra Energy, as well as served at the Federal Energy Regulatory Commission, or FERC, where she both worked as a trial attorney and as a legal advisor to FERC Commissioner Mark Christie. Next slide, please. Start the legislative portion of the webinar with some of the biggest bills in the renewable energy space from this session: community solar, or as we call it here in Virginia, shared solar. Currently, there is a limited 200 megawatt program in Dominion Energy territory. The first 150 megawatts have already been claimed and are under development. The remaining 50 megawatts have not yet been released by the SEC, but the waitlist for this capacity, which is publicly available, is already over 50 megawatts. A minimum bill is required for program participants, which equates to roughly between $55 and $65 a month, which is proven to be prohibitively high. Low-income participants are actually exempt from this minimum bill, however, which means that the current shared solar program in Virginia is functionally 100% low income. As for Appalachian Power Territory, no such program exists. For those who have been following along with these webinars over the last several years, you're no doubt aware that the number of efforts to expand shared solar have been numerous and strong. but unfortunately, none have successfully survived the General Assembly until this year. Next slide, please. First set of bills we'll highlight, Senate Bill 253 from Senator Scott Surovell and House Bill 106 from Delegate Rip Sullivan expand and revise the Dominion Shared Solar Program. These bills were heavily negotiated and went through countless revisions over the course of session. In their final form, this legislation effectively releases the remaining 50 megawatts of capacity from the existing 200 megawatt program and expands the program by up to another 150 megawatts. There is a trigger for this expanded capacity, however, and the SEC must determine that at least 90% of the initial program has been subscribed and that construction of the projects is substantially complete. This legislation also directs the SEC to recalculate the minimum bill and to include the benefits of solar to the grid. Beyond the additional elements that the SEC will now consider, another key provision of this legislation that will affect the minimum bill proceeding is that going forward, all RECs for the next phase of the program, so RECs from the next 150 megawatts, will be transferred to Dominion for retirement for compliance with their RPS obligations. Finally, this legislation also seeks to provide incentives for projects that are located on rooftops, brownfields or landfills, or are dual-use agricultural facilities. As I alluded to a moment ago, this bill started as a much more aggressive and frankly community solar-friendly bill, proposing over 1 gigawatt of capacity, as well as stricter guardrails on the minimum bill calculation. Ultimately, however, due to fierce opposition from the utility and concerns from General Assembly members, including the patrons, these bills were scaled back and negotiated to where they are today. SB 253 and HB 106 passed both the House and Senate with narrow but bipartisan votes and are currently on the governor's desk awaiting action. Next slide, please. On to the Appalachian Power bills. Senator Surovell and Delegate Sullivan also introduced bills seeking to establish a new shared solar program for Appalachian Power Territory, which is prominently in Southwest Virginia. As introduced, these bills would have established several hundred megawatts of community solar capacity in APCO territory and provided strict terms for the minimum bill calculation. But just like the Dominion bills mentioned, these two were met with fierce opposition by the utility and concerns from legislators. Ultimately, these bills were negotiated down and in their current form succeeded in passing the General Assembly with narrow but bipartisan support. The APCO shared solar legislation proposes what is effectively a pilot program, offering a 50 megawatt program and a minimum bill calculation that requires heavy consideration of the value and benefits of solar. This legislation too incentivizes projects that are located on rooftops, brownfields, or landfills, or are dual-use agricultural facilities. RECs from these projects will be transferred to the utility for RPS compliance, much like the new Dominion bill. One key difference in the APCO program as compared to the Dominion program is that there's no exemption from the minimum bill for low-income customers. As noted on this slide, this is a result of the utilities and General Assembly's concerns about potential cost shift to non-subscribers in APCO territory. Like the Dominion bills, these bills both passed and are awaiting action from the governor. Next slide, please. Permitting. I'm guessing that if you're a developer on this call or a trade association with developer members, you are all too familiar with delays in getting your projects built. Maybe it's been supply chain issues or labor shortages or federal permitting delays or interconnection delays. One way or another, we're all dealing with major delays. And in some cases, we've seen permitted projects wait years to begin construction, only to have to continue to wait, and then eventually go back to the local government for a permit extension or a new permit. And often at this point, this comes with new terms or even a permit denial. The legislation before you seeks to address this. House Bill 650 from Delegate Kerry Coyner establishes a minimum period of validity of 3 years for all special exceptions, special use permits, or conditional use permits for solar and battery storage projects. This bill also establishes a minimum period of validity of 3 years for residential development projects. It's important to note two things here. First, this bill does not require any permit to actually be granted. It simply says that if a permit is granted, it must be valid for at least 3 years. Second, this bill is purely prospective. It only affects future permits granted after July 1, 2024. All told, given this unique set of stakeholders, the solar developers and the residential home builders, the soft touch of this bill, and the robust support from the industry that this bill enjoyed, this legislation passed with flying colors, passing the House 86-10 and the Senate 37-2. And in a positive development, just last night, Governor Youngkin actually signed this bill into law. And before I move on, I did get a question on this bill about what does the 3-year period require? Does that mean a project must be completed? No. The 3-year period for this bill is for a project to commence construction. Next slide, please. This permitting legislation did not fare quite as well as the last bill. These two bills, Senate Bill 567 from Senator Creed Deeds and House Bill 636 from Delegate Rip Sullivan, proposed a new permitting procedure for Virginia. Essentially, this legislation proposed a new method in which an applicant could obtain siting approval from the SEC rather than the local government. This bill, which was in large part modeled on the recently passed legislation from Michigan, hence the nickname the Michigan model, incited fierce opposition in the General Assembly from a number of parties, including local governments, the agriculture and forestry industries, conservation groups, activist groups, and numerous legislators from rural localities across the Commonwealth. As a result of this opposition, these bills swiftly ran into trouble, and ultimately the patrons opted to continue these bills to 2025, which is a soft way of killing the bills this year while keeping the conversation alive in the legislative offseason. They've asked the newly revamped Commission on Electric Utility Regulation, CEUR, or as it's affectionately known amongst the Capitol community, the sewer, to look at this issue in the offseason. These bills, or at least the concepts behind these bills, will be one of many issues that sewer looks at this summer, and we'll be closely monitoring these proceedings. Next slide, please. While we're still on the topic of local government control, Senate Bill 697 from Senator Schuyler Van Valkenburg is an important piece of legislation to mention. SB 697 sought to prohibit localities from enacting bans, either outright bans or de facto bans, on solar or battery storage projects. Instead, the bill intended to require each locality to simply take up each project for consideration and vote on it. There was no requirement whatsoever that any project actually be permitted. In fact, there was language in the bill that specifically stated that nothing shall require a locality to approve any application for solar or energy projects. Simply put, this bill would require a locality to hear a project on its merits and then make an informed decision. As the session wore on, the patron ultimately agreed to amend the legislation to even soften it further, ultimately agreeing that if a locality already had 4% of its land under panels, then it could outright ban solar. It didn't require any locality to develop 4% of its land. It simply provided an off-ramp for localities who had maybe been early adopters of solar and had lots of land under panels. Despite this legislation's light touch, and despite the concessions made by the patron and the industry proponents, this bill still incited fierce opposition. In large part, this opposition was driven by misunderstandings and misinformation about the bill, confusion about what the Michigan model was versus this bill, and frankly, we heard numerous comments and saw numerous articles and press releases about how this would actually require solar developments to be permitted, regardless of the explicit language to the contrary. SB 697 passed the Senate, but unfortunately was unable to find a path out of the House. So Senator Van Valkenburg ultimately opted to continue this bill to 2025 and examine the issue more in the offseason. Next slide, please. While we're wrapping up our discussion on permitting, I think it's important to touch for a moment on judicial review. Senate Bill 580 and House Bill 122 proposed streamlining and simplifying the judicial review procedures for DEQ decisions. Specifically, if a project submitted through DEQ's permit by rule or PBR process were to be denied by DEQ, then the aggrieved party could seek review in the Circuit Court of Richmond rather than where the project or local DEQ office is located. This legislation also requires that the appeal be filed within 30 days of the decision and requires the court to hear the appeal as fast as practicable, ensuring that it is as efficient and effective a process as possible. Really, this legislation aims to pull DEQ into the same appeals process that many, if not most, agencies in Virginia already have. In other words, when an agency decision is appealed, it's usually appealed to that agency headquarters jurisdiction, as it's understood that that jurisdiction likely understands the agency's purpose and processes best. Senate Bill 580 and House Bill 122 passed both chambers and currently await action from the governor. Next slide, please. Other set of important bills from this session dealt with net metering. SB 271 from Senator Suhas Subramaniam and House Bill 1062 from Delegate Rodney Willett aim to remove barriers to residential solar by clarifying that lease arrangement for rooftop solar are, in fact, legal. This legislation stipulates that no contract, lease, or other arrangement by which a third party owns, maintains, or operates a solar facility on an eligible customer generator's property shall constitute the sale of electricity or cause the customer generator to be considered an electric utility. This bill also offers clarity about what kind of insurance that a customer generator is required to carry and allows customer generators to participate in demand response, energy efficiency, and/or peak reduction programs. These bills both passed the House and Senate and are currently before the governor. Next slide, please. Another bill that's aimed at rooftop solar that's worth mentioning today is Senate Bill 313 from Senator Van Valkenburg. This bill stems from concerns and complaints that the patron heard from constituents about door-to-door solar salesmen and confusion about what kind of services they offered or what savings they guaranteed. In its final form, SB 313 did a number of things, most notably requiring that a statement of customer protections be offered to the homeowner and requiring DPOR to adopt new regulations for contractors and subcontractors about what consumer protection terms must be included in future contracts. There were a number of other provisions that establish new DPOR or Board of Contractor requirements, but in the interest of time today, I'll leave these for your own review. Finally, the SEC is required to convene a stakeholder group this summer to further explore possible consumer protections and deliver a report and potential legislative recommendations to the General Assembly in time for next session. SB 313 passed both chambers and is currently on the governor's desk. Next slide, please. Brownfields. For years, we've heard talk amongst developers, solar advocates, environmental advocates, and legislators about how do we better incentivize solar development on brownfields or other non-ag or non-forested lands. Senator Hackworth's Senate Bill 25 and Delegate Krizik's House Bill 199 seek to take this idea further, proposing revisions to the Brownfield and Coal Mine Renewable Energy Grant Fund. This fund, established via legislation in 2021 from Delegate Terry Kilgore, awards grants to energy projects that are located on brownfields or previously coal-mined land. One pinch point, for lack of better words, in the original legislation is that there can be no allocation of funds unless there are federal funds that cover the entire allocation. Senate Bill 25 and House Bill 199 remove this requirement. These bills have both passed the General Assembly and await action from the governor. I will note, however, that even if these bills are signed, unfortunately, there's currently no state funding for this program in the current or proposed state budgets. Next slide, please. I know we're running short on time here, so I want to go through these next few slides quickly. First up, the Regional Greenhouse Gas Initiative, or RGGI. As you're likely aware, Governor Youngkin removed Virginia from RGGI early in his tenure, much to the chagrin of House and Senate Democrats who had spent years fighting for Virginia to simply join RGGI. Unsurprisingly, now that the Democrats are once again in control of the House and Senate, they have included language in the budget bills that require Virginia to rejoin the compact. The budget bills are, like the rest of this session's outstanding legislation, currently before the governor. Now, there are hot topics, there are hotter topics, and then there's the state budget, which is the hottest topic and biggest sticking point, and frankly, most divisive issue in Virginia politics today. The governor has expressed his extreme displeasure with the budget proposal that the General Assembly sent him, which also removes his proposed tax cuts, adds certain tax increases, and makes major changes to his initially proposed spending priorities. He's even delivered speeches across the Commonwealth in recent weeks, decrying the quote-unquote backward budget. Even before the budget showdown that we've been watching unfold for the last month, the governor parsed no words about his opposition to RGGI. So what happens next? Anybody's guess. He may send down major amendments to the budget, or he may veto the budget entirely and call back the General Assembly later this spring or summer to start fresh. Only time will tell. But whether it's in this current budget or in a future proposal, it's safe to say that under this administration, RGGI remains in trouble. Next slide. We're coming into the home stretch here. So before we part, I do want to mention two other pieces of Virginia's energy puzzle that haven't really been addressed yet: wind and nuclear. First, we'll start with offshore wind. Senator Deeds introduced legislation this year, Senate Bill 578, that proposes new competitive procurement requirements for offshore wind projects. Specifically, for projects other than the currently underway Coastal Virginia offshore wind project, so for the next 2.6 gigawatts of capacity, Senator Deeds proposed that there must be a competitive procurement process held by Virginia Energy. While this legislation had a lot of buy-in from a number of developers and other advocates in the industry, it was, like many other energy bills this session, continued to 2025. Next slide, please. And finally, nuclear. It's been a key issue from day one in this administration. And once again, small modular reactors, or SMRs, were an important issue for the General Assembly. Senator Dave Marsden introduced legislation, Senate Bill 454, that allows Dominion to petition the SEC for rate adjustment clauses to recover the costs associated with SMR development. Notably, Senator Marsden's legislation contains both an expiration date of December 31st, 2029, and a cap on a potential rate increase at the equivalent of no more than $1.75 per month per customer. Delegate Israel O'Quinn introduced the APCO companion legislation, HB 1491, which would permit APCO to petition the SEC for rate adjustment clauses to recover costs related to SMR development. Like the Dominion bill, this bill also has an expiration date of July 1, 2034, but notably, it does not have a cap on the recovery amount. Both Senate Bill 454 and House Bill 1491 have both passed the General Assembly and currently await action from Governor Youngkin. Next slide, please. So that concludes my remarks for today. I want to thank everyone for tuning in and look forward to continuing the conversation with you either now or in the future. I really appreciate your time, and I'll turn things back over to Brad.
Great, thanks, Chris. And I'll just mention earlier in our slide deck, we actually have links to all the bills that Chris covered today. So if you've got any questions, you can either refer back to those links or feel free to contact Chris or myself. Before we get to, I know we've got just a couple minutes left. Before we get to questions, I just want to mention that our next webinar in our webinar series is on May 8th. We'll send out an invite, and on that topic, we're going to be covering solar and energy storage siting agreements, including the process that's involved and current market trends. So please look out for our invite on that. We also have several other webinars in our webinar series, including we're going to talk about CPCNs for solar and energy storage projects, prevailing wage and apprenticeship requirements for contractors. We're going to do a recap on state and local taxation for solar projects and energy storage projects in Virginia. We're also going to talk about key provisions in solar M&A transactions. Next slide. So we've got a couple questions we're just going to address. The first one is, Chris, what does SEWR stand for, and how can one get involved in that process later this year?
SEWR is the Commission on Electric Utility Regulation, CEUR. It's been around for a number of years. It was kind of not quite mothballed, but rather defunct for the last several years. But for the first time in a number of years, it now has funding, and they're actually hunting for an executive director. SEWR will meet throughout the spring, summer, and fall in the lead up to the legislative session. They will publicly notice their meetings. As for getting involved, I'm happy to chat with you offline about this. You're also welcome to reach out to the members of SEWR. It's a number of legislator and non-legislator members. And I imagine once the executive director is finally appointed, we'll have a little bit better idea of what the schedule will look like, what public input will look like.
Great. Let's get to just one more question. For the Dominion APCO shared solar bills, does the SEC need to adopt regulations? And if so, what's the timing on that?
Yeah, so it's a good question, Brad. And there is going to be a lot of activity at the SEC regarding these community solar bills. The APCO bills do direct the SEC to establish the new program by January 1st, 2025. And then subsequently, the SEC is required to file all tariffs, agreements, and forms necessary by July 1, 2025. On the Dominion side of things, the Dominion bills require the SEC to establish the revised shared solar program by March 1st, 2025, and then require all new tariffs, agreements, necessary forms, and whatnot to be filed with the Commission by December 1, 2025. All existing tariffs for Dominion will remain in effect until the newly revised program is filed and accepted. Also important to note with Dominion, which will kind of further muddy the timeline a little bit, is that the expansion of shared solar in Dominion territory does have a trigger. The legislation that passed does stipulate that the SEC must determine that 90% of the initial program is subscribed and that construction of the projects is substantially complete before they can release the up to 150 megawatts further. So a lot going on at the SEC over the next really year and a half that we'll be following along, and I'm sure we'll be providing updates, via web alerts, if not another webinar in the future.
Great. Well, it looks like we're just out of time. So if we didn't answer your question this morning, what we'll do is we'll follow up separately. And thank you again for attending today's program. Have a great day.